Okay, so here we go again. We're really excited today to have Riah Greathouse with us. Since being admitted to practice law in the state of Georgia, he has been counsel of record in over 5,000 criminal and civil matters throughout the state with a high rate of success. He earned his undergraduate degree at Hampton University and his law degree from the Thurgood Marshall School of Law at Texas Southern University, where he graduated in the top 10% of his law school class. During his law school tenure, he gained invaluable experience with internships with Judge Clarence Cooper of the United States District Court in the Northern District of Georgia, as well as Chief Judge Myra Dixon of the State Court of Fulton County, Georgia. These internships allowed him to gain a keen insight on the method in which judges operate and how many of them expect attorneys to be prepared when appearing on clients' behalf. Following law school, Mr. Greathouse joined a premier DUI defense firm, and he also served as an assistant district attorney in Fulton County. His service as a prosecutor yielded a tremendous amount of courtroom experience, allowing him to attack cases with tenacity, often proving to be beneficial in securing a favorable resolution. After leaving the Fulton County District Attorney's Office, Mr. Greathouse joined a nationally recognized plaintiffs firm where he represented injured victims as well as estates on behalf of decedents in wrongful death actions. Since starting Greathouse Trial Law, Mr. Greathouse has been selected to National Trial Lawyers Top 40 Under 40, the Georgia Super Lawyers Rising Stars, has secured over $50 million on behalf of injured victims, and has built the nation's fastest growing small law firm in 2020, according to Law Firm 500. Please welcome GCA Gold Partner, Riah Greathouse.
Thank you so much. That made me sound way more important than I am, but much appreciated. So happy to be here. I know a couple of y'all I know, and for those of y'all who I'm meeting for the first time, I certainly hope to get to know you. You know, one of the things that I like to do is to educate. I absolutely love it, whether it's a client, whether it's, you know, a colleague, medical provider. I just love it. I'm a nerd about this stuff because I think it's so fascinating and it's so important that we understand our craft. With that said, I've got a small PowerPoint. You know, I'm not going to be long-winded. I wanted to make sure that I brought out kind of the key points that you guys can take away when preparing for a deposition or in a deposition. But I wanted to make sure I leave some time for us to talk about it afterwards if you guys have any questions or want some feedback or anything. But I always say, you know, from the attorney side, you approach every case as if you're going to have to present it in front of a jury. Every case you're prepping for trial for day one. Obviously, we prefer for it not to go to trial. You know, we want to ensure that there's a settlement because obviously it's quicker and that way we can control the outcome a little more. We know that we're settling on an amount at that point, as opposed to when we toss it up to a jury. We always say that anything can happen when you put 6 strangers, or if you're in a superior court, 12 strangers in a box, or the jury box. So I'll get started on the slideshow. Let me see if I can share my screen. Let me start this. Oh, I guess it would be helpful if I shared it first. Give me a second. All right. Can y'all see this okay? Everybody can see this? Perfect. All right, well, Deposition 101. So let's first understand exactly what is a deposition. Some of y'all may have heard of it, others may not. I guess before we even jump into it, how many of y'all on here have actually been in a deposition before? Just Dr. Garcia? Okay. So understand that a deposition occurs, you know, that means that obviously a lawsuit has been filed and you know what's called the discovery period of a lawsuit. That's where all parties are getting their facts together. They're exchanging information where they're, as it says, discovering what the facts are and what are the positions of each side. So a deposition is defined, it's a discovery tool used by the parties to a lawsuit where it's an opportunity for an attorney to examine a party, that's plaintiff or defendant, a witness, or expert, and it's under oath regarding their knowledge of the facts and potential testimony at trial. So, what usually happens, you're in a room, it may be at your office, or it could be at plaintiff's counsel's office or defense counsel's office, and it'll just be the lawyers, you, and and a court reporter, and that court reporter is going to swear you in, and you're going to get a chance to be asked questions where you'll have to answer. So this is the statute that defines it, and if any of you guys care enough to look it up, it's OCGA 91130, which basically governs the rules of depositions. So it's the examination and cross-examination of witnesses. And what that is, with cross-examination, some of you guys may have heard that before, but that's basically where usually the defense counsel will get to ask you questions, and they can ask leading questions, which means, kind of questions that will make you either say yes or no and so forth. But this is their chance to interview you. And I use that word intentionally when I say interview, because that's essentially what it is. It is an interview. When you are in a deposition, yes, the facts are important. Absolutely. You want to, the attorneys want to learn about the case. They want to know what you know. But most importantly, this is their chance to get an idea of who you are and what type of testimony you will give. It gives them a chance to essentially preview how you're going to be in front of a jury. If you come across as an incompetent asshole, then chances are I'm going to go ahead and I need to know that in the deposition, because that's the time where I can say, you know what, maybe we need to settle this case, or maybe, this is something that I need to maybe go back and do some redirection or have some conversations with the provider to make sure that we can correct it before trial. Or in the alternative, I hate to start with the negative, but, for the positive, I can say, you know what, this doc is a rock star, and I think the jury is going to absolutely, love this testimony. You're going to enlighten them. And in fact, it further validates everything that we thought about our client. And now I have more bullets in the chamber that I am absolutely confident about taking this to trial. So that's kind of just an overview of the deposition. So let's jump into preparation. The easiest things that you can do to prep. And I say it because it should be common sense, but unfortunately, we've come across a couple of times where it wasn't, second nature. So I would say, number one, review your chart. Review. I mean, just like you would never walk into a job interview without, doing research on the company or the role or so forth. Same thing in this interview. Review your notes, review the charts. And in fact, create yourself a cheat sheet. Create a timeline summary of your treatment. The first thing that I want to say is that preparation is key. This is not a memory test. It's not a pop quiz. This is something where you can prepare and you can create that cheat sheet, and then you can even bring it into the deposition with you. Because if you have a smart attorney, then he or she is going to know that you can look at that chart and during your deposition, because if the other side objects, then the way that I overcome that objection is I say that you're allowed to what's called refresh your recollection. You can take a moment to look at anything to refresh your recollection, as as that statute says, that jogs your memory and your memory and gives you a chance to be more accurate on your testimony. So this is not a guessing game. This is not a memory quiz. Review the notes, create a cheat sheet for yourself. Second part of that, talk to the lawyer, talk to the plaintiff's attorney, talk to your client's attorney. I've oddly gotten pushback before from providers who act like they don't have the time to talk to us about the case. And it's like, hey, we all have the same goal in mind. You guys want to get paid, right? And I'm trying to make sure that your bill gets covered. So we need to make sure that we're on the same page, because there may be, something where you're gonna educate me on something. There may be something in the record where I say, Doc, hey, here they're testifying that it's their pain scale is a 4 of 10. And I noticed you did this action. And then I see, on the next week, they're saying an 8 of 10. What's up? Can you explain that? Can you maybe enlighten me on why that is? So now I know what to highlight, what I need to bring out in the deposition. There may be some tidbits that could that could be flags about my client. I want to know that. Or there could be something where you may say, hey, focus on this point because here's something that I noticed in their chart that I think that is really important for me to highlight. So can you ask me about this so I can elaborate? I think that's so important. I cannot overstate enough the need for communication. So preparation's real easy. My 2 points that say, number 1, review your chart, create a cheat sheet. Number 2, make sure that you brief the attorney prior to the deposition. A few of the ground rules in going into the deposition. My 3 factors. Number 1, appearance matters. As I said before, this is a chance where you're getting interviewed. They want to know what type of witness you're going to be. Get a good night's sleep. Be refreshed. You don't want to come into the deposition where you're looking all frazzled and disheveled, and you look like the mad doctor who doesn't have a clue what's going on. Eat breakfast if it's a morning deposition. If it's a later in the afternoon, eat lunch. Don't starve yourself. We don't want the hangry doctor coming out. We don't want the Snickers commercial where you're, saying crazy crap and, things where you're not your best version of yourself. And then 3rd, dress properly. I know that a lot of times the preferred attire is you may just want to wear your scrubs. That's fine. You're a physician. Wear your scrubs. If you're not wearing scrubs, then I would say business casual. It's not a stuffy environment where you want to wear a suit or ladies, you want to wear the business suit. It's not that type of environment. Men, I always say, a blazer with an open button is fine. One tip that I actually learned during my days as a prosecutor is we were taught to read body language. So when you wear a tie, as you get uncomfortable, you may unloosen it. And a lot of times that can be misconstrued as that you're irritated or you're uncomfortable or you're on the hot seat. So just small things, it's just kind of fidgeting with your tie and kind of fixing yourself, may be misunderstood or misinterpreted as negative body language. So just a tidbit, don't worry about wearing a tie, but I always say, look, just be comfortable, wear your scrubs. That's fine. Not a problem. So those are my 3 tidbits. Good night's sleep, eat breakfast or lunch, dress properly. So also what I kind of noticed, the rules of engagement, the 3 steps, and I'm just going to keep emphasizing that you are being judged on your looks, your presentation, and so forth. Be courteous. Nobody wants this snarky know-it-all witness, whether it's my client, whether it's a witness, whether it's a physician. Just be courteous. Don't take anything personally. These aren't attacks on you. No one's saying that you're an awful doctor. Where even it's the plaintiff side where, we may say, well, why didn't you do, something, or why did you decide to do, X over Y, or the defense attorney may say the same thing. They're not taking, it's not a personal attack. So as long as you remember, this is about the client, this is not about me. There is a hidden agenda, but it's not the agenda to attack me personally. You'll be absolutely fine. And with that said, maintain your composure at all time. You can take breaks. You can ask for breaks. You can ask the attorney. I know several insurance defense attorneys who are just long-winded. I think they're jerks and they take way too long. But I always say, look, maintain your composure. And if it's getting lengthy, just say, hey, look, do you mind if we take a 5-minute break? Do you mind if we take a 10-minute break? That's okay. I would rather you do that to collect yourself than to be frazzled or hot and bothered and you're saying something that could ultimately tank the case. All right. So to jump into the substance of a deposition, I say that there are two parts. There are two different strategies that are going to be explored in a deposition. I'm sorry. So the first of that in the deposition is you're going to talk about your personal and your professional background. The second half of that is when they talk about the care and the treatment of the patient plaintiff. So here's what a sample background, line of questions looks like. And what you're doing there is you're essentially what's called laying the foundation. This is my chance to qualify you as a competent expert in this field. So of course, I'm going to ask you to identify yourself, what type of professional practice you have. Tell me about your education. Tell me about your continuing education. Tell me about your license. What type of license do you have? Are you a specialist? Do you have a board certification? Tell me about your hospital affiliations, your teaching responsibilities, other affiliations. If you've done any research, any publications, this is my chance to, as I said, qualify and show that you are experienced. You know what you're talking about. This is important because obviously this is going to lend serious credence or give you credibility as to what you're talking about. So very important to go through this. Obviously, you're going to know more about yourself than anybody else. So this is your time to shine and talk about how wonderful you are at what you do. And then jumping into the second half, which is, the most important part of it, the medical testimony. And these are the bullet points that I say are probably the most important that you want to understand. Number one, understand the question. If I'm asking you about, subluxation, don't talk to me about, headaches and a bunch of irrelevant stuff that doesn't matter. Just answer the question, listen to the question, answer the call of the question, meaning, what are you asking me and what is the best, most succinct way to answer that question? If you don't understand the question, as I said earlier, it's not the guessing game. We're not trying to catch you off guard. Say, can you repeat that? And then, chances are I'm going to rephrase the question or break it down in a manner, that you understand exactly what I'm asking. Or, as an attorney, we may get it wrong. We may ask something that makes absolutely no sense to you. So, I want you to obviously politely correct me and say, oh, are you asking me about, A, B, and C? And then at that point I can say, yes, that's exactly what I'm asking. And then you can begin to go ahead and testify about that. Don't volunteer information. When we are asking you our questions, we prep this outline. I always say that it's like we're directing a movie or we're directing a play or telling a story, whatever metaphor you want to use. And there is a reason that we are asking you this question, especially in this order. So it's very important that you specifically answer that question and you don't volunteer something, because it may be something that I may not necessarily want you to bring up. I don't want you to jump and start talking about, yeah, it's a pre-existing issue that I noticed that, she told me she'd been in 3 accidents prior. Well, that's not what I asked you. And now I'm caught off guard because you've just brought up something that I wasn't asking you. And now I've got to find a way to clean that up. Or it may be that, hey, I was going to ask you about the 3 other accidents prior, but you didn't even give me a chance to do it in the order. And now, you possibly let the cat out of the bag, and that could have potentially prejudiced, my line of questioning. So answer the call of the question, so important. Thirdly, always answer truthfully. Don't lie for anybody. Let me just say that all of us are here because this is our profession. This is our way of making a living. One case is not, or it shouldn't make or break you. And that's what I always say, you know, when I look at some of my colleagues and they do unethical things, I just, it blows my mind, because it's something where it's one client. There will always be more. Um, I say always answer truthfully, because you know, this is under oath. Number one, don't perjure yourself, because that is a crime. Um, and number two, you know, it's being recorded. There are other depositions that this can be used against you. Please believe that the defense bar, they're going to see how you testify. They're going to see what you're saying, because they can use that against you to do what's called impeaching you, or essentially they'll make you look like a liar, and your credibility is going to be shot. We do it all the time with these experts, in air quotes. I know you guys can't see me, see my screen. That, you know, State Farm and everyone else always hires the same doctors to say why our client isn't hurt and they're never hurt. And we can say, hey, doctor, you know, it's true that you've testified over 100+ times in the last year. Is that correct? Yeah, it is. And it's true that out of those 100 times, out of 100, you said that no one was hurt, correct? Well, yeah, but no, I didn't, you know, and that's how you catch it. So you're the same thing, you know, be credible, stand by your words, say what you mean and mean what you say. So, you know, use your credibility, and you never want it to get out that, you know, you're not usable. Don't take your career to where lawyers don't want to send you cases because we say, well, that doc's tainted. Yeah, it'd be great if we settle it pre-lit, but if it goes to lit, this doctor is not going to hold me down because they're not credible. Problematic. And then, you know, with going with number 3, don't guess or speculate. If you don't know, you don't know. It's okay. Hopefully, you know, during your refresher and your cheat sheet, you'll have the answer to it there. But, you know, you're not guessing, you're not speculating. Another thing that you know, what these defense attorneys try to do is they try to put you in a position where you are speculating. Only answer what you know. If you don't know it, it's okay. I'll take an I don't know over a wrong answer or a speculation. So in breaking it down in that medical testimony, here are the 6 main topics that they're going to be asking you questions on. The first, they're going to ask you about your records. Do you keep records? Obviously, the number one answer should be absolutely. You know, you keep records in the course of your business, but you're going to have to explain your records, your method for taking records. At what point do you memorialize the treatment? You know, how fresh after seeing the patient? You know, is this something where you don't even start the records until after the client's been released from treatment, or is it fresh? Obviously, if they're fresher records, then it's going to be more accurate, because, you know, if you're saying, well, I just treated the patient, you know, 10 minutes ago before I did this, then obviously that's going to be more accurate. You know, in this as well, you know, they're going to ask you the substance, and this is your chance to talk about, you know, why you did certain procedures. This is your chance to educate about the type of injury and about the type of treatment that corresponds with that injury. So this is the most important point, number 1. You know, when they're talking about the pain scale and symptomology and so forth, this is why this is so important. The second part, you know, they're going to ask you about communications. Well, what did the patient say? Did they, you know, how long did they say that they were in pain? Or, you know, did they tell you that, you know, they were experiencing certain symptoms? One of the things that, you know, I always get calls about, probably the most frequent call that I get from some of our partnering, you know, providers is, hey, there's a gap. How do I address the gap in treatment? And this is where number 2 comes in. Well, did you talk to the client about why there's a gap? Yeah, because they said that, you know, they didn't have any transportation, and they sat on their couch in pain, or it was a guy who was, you know, big manly guy that said he wanted to, you know, toughen it out at home, and he's been taking pain meds from over the counter for the last 2 weeks, and finally he decided he couldn't take it anymore. Put that in your records. It's okay. You know, there's nothing that I love more then explaining the gap. You can put that in your records. You know, in telling that story, you got to connect the dots. Just explain it to the jury. Gaps happen, life happens. If it's something logical and makes sense, oh yeah, well, yeah, he didn't have a car and that's why he didn't come to me for 2 weeks. Well, yeah, that makes sense. Why? You know, as opposed to just accident date, you know, July 1st, treatment date number 1, you know, July 30th. And then you never address it. That's going to get exploited. They're going to hammer on that all day. So it's so important for you in those records to be able to flesh that out. Hopefully you've put it in there, but if not, then bring up those communications with the patient. You can talk about that. It's not hearsay because, and if they objective hearsay, then my answer would be, it's not hearsay because it's not trying to prove that they were in pain, but more so it's explaining course of conduct. It explains why they didn't get into treatment, and hopefully your, you know, attorney is smart enough and familiar enough with the rules of evidence to allow that testimony in. And if they're not, then you know, only work with me because I understand the rules. That's a plug for me. I'm just joking, kind of. But so questions regarding you know, other healthcare providers. You know, if you you know, co-manage it with pain management or even physical therapy, and you talk to them, you know, talk about it. You know, if you've had firsthand knowledge, if you've gotten a chance to review their records, talk about it, explain it. Because I'm going to think it's odd if you don't know anything about it. Then it's going to say, well, what were you doing? Were you just only focused on your own bills and records and you getting paid, or did you care about the welfare of the client? So, you know, I always say, help yourself, review the other providers' records and notes and how that corresponds with the treatment that you provided. But I will say, going back to the other point, if you don't have knowledge, if you don't know, then that's okay. Just say you don't know. I don't know. I haven't had a chance to review those records. The fourth point, questions regarding your charges and bills. And this is something where, you know, when the defense can't attack your treatment, they go to your charges and your bills. They, you know, always try to say, well, I see here you charged $100 for your ice packs. Why'd you do that? What made you do it? Why'd you charge them each time? Why didn't you use the same ice pack? Or, you know, I see that you billed this CPT code, you know, why not this CPT? You know, just be prepared to answer why you charge the way that you do. You know, I don't know doesn't cut it. Or, you know, folding in and just saying, oh, well, I just heard that's what everybody else does. That's not a good answer. Explain why you charge, you know, stand by your charges. They are what they are. And then, you know, time estimations. This is why that cheat sheet is so important, because chances are you're not going to remember, you know, hey, I saw him on, you know, 3 days out of this week, and then I told him to come back 24 hours. You're not going to remember that. So this is the chance for you to connect the dot and say, look, this was the time frame that I told them to treat. You know, this is the average time frame based on this injury that, you know, I would tell a client, you know, follow this regimen and this is how you get your best results. So be prepared to talk about that. And then lastly, you know, those hypothetical questions. This is where these are the trickiest. This is the trickiest part, because you want to stay out of the hypothetical. What my answer to this is always, every client is different. That's how I would suggest that you answer it, because the insurance company is going to try to nail you down and just get you to say that it's one size fit all. And if you don't fit into that, you know, square peg, that square hole, then you did something wrong. Every client is different. That's how I would suggest that you answer it. And based on this client and how they responded, that's how I customize the treatment for them. Because there are mills out there, and I'm not going to name anyone by name, where we all know it's one size fits all. It's you get into a room, and regardless of if you're saying your cervical hurts or your sacrum hurts or whatever, you're going to get the same treatment, right? They're all going to tell you, you got 16 treatments, you come for 4 weeks and 30 minutes a piece, and then we're going to cut you loose. That's not the way it works. So you want to make sure that you are positioning yourself to where you can answer specific to your case and you're not falling into the trap of these hypothetical questions where you are speculating on someone that you've never seen or you've never treated. And that is probably the most important point that I really kind of wanted to end on, to give you a chance, you guys a chance to ask any questions, or that I could give you feedback and so forth, to help you guys out with your cases. So that's essentially, what I wanted to cover. I promised I wouldn't be too long. I wouldn't be long-winded. I wanted to make sure I got about 30 minutes. I had it 30 minutes on the dot. So let me know what I can do to help, if there's anything specific that you want me to discuss or clarify for you guys.
Riah, this is Valerie. Could you give us a couple of examples of depositions that went wrong, so we kind of know what not to do?
Depositions that went wrong. Yeah, well, you absolutely don't look at your notes. And I'm sitting here asking you about, a client named Bob, and you keep referring to Mrs. Jones. I've had that happen before. And it's obvious when you haven't done your homework. As I say, the example where it's an issue, it's a cervical issue where we've had to, get it referred out for the MRI and then on to pain management, eventually surgery. And you're sitting here and you don't even, I mean, fortunately this wasn't in a deposition, but this was the pre-depo call where you don't even know that the client had surgery. I know it sounds crazy, but this is what some of your colleagues have done. So I mean, that's what really jumps out as an example. I know Dr. Garcia, you just raised your hand. You had a question specifically?
Yeah, so I actually have a couple questions. Can you hear me okay? Everybody can hear me?
Yep.
Well, the first question is relatable to, maybe it's more relatable to a person who is not in solo practice, maybe someone who has associate doctors and or coverage doctors and what have you working on clients. How does that work when, you have a patient who, you're handling their case, and maybe they had multiple chiropractors, or maybe let's just say 2 chiropractors working on them, and one of them is no longer with the practice. And so then you go, and you're still handling the case. Your practice is still the custodian of the record.
Yeah.
And so, and maybe that person moved out of state or something like that. They're not available. So how does that work for deposition purposes, and just, these questions that will come on the record?
Sure. That's a phenomenal question. So I'll start back to, I will assume that, because you're the custodian of the records and everything, that you have had a chance to go through the entire record, correct?
That's right. Yeah.
So,
we still have the record, so I'd go through it.
So as long as you've had a chance to go through the records and you now have that knowledge, then you're able to talk about, what that physician did, as obviously as best as you can. Now, if it falls into well, why didn't he do X instead of Y? You can't answer that, and I'm going to object, because now that calls for speculation, that calls for you to testify as to what somebody else was thinking, or, so that's something that, a good lawyer is going to object and make sure you're not going to have to answer that. But it's not problematic if someone has left you and, you still have the records. That's fine, as long as you review it and can talk about what happened and why. Does that answer your question?
Sure does. Thank you.
Okay, sure thing.
I have another question, if that's okay.
Yeah.
This is relatable more on, I want to say, the receiving the request for a deposition, and or maybe, you can get it a couple ways. I think you can be subpoenaed to court,
Yeah.
or you could be asked to come and can you to the different ways where people can be made to come to court, and or I should say chiropractors, doctors, and then how the different ways affect whether or not they can be compensated for their time in deposition and or like court appearances and such like that.
That's a great question. And I will actually, I didn't look up, I should have had that in preparation. I can supplement it when I send it to you guys, what the actual statute is and what the rules are regarding compensation. Cause obviously, you know, I know you want to get compensated for your time, because when you're doing this, then obviously you're not with your patients, which is your moneymaker. I always like to just communicate and say, look, you know, doc, we need your testimony. This case isn't lit. You know, just give me a few dates that are convenient for you. You know, there's no point in me blindly noticing a deposition, because that's what you do. You file it, you know, do what's called noticing a deposition, and then you can be subpoenaed, which means, hey, you have to appear at this time under court authority. But I feel like that's so formal, you know, that let's work together. Let me say, hey, what, you know, these are the dates. I need to get this done. Let me know what works best for you and how to handle it. And, you know, let me know what your fees are up front so I can calculate that. And, you know, if it's my deposition, I want to obviously be mindful of your time. And I want to also factor that into my client, you know, into our costs on the case. You know, there are some matters where we may talk, and based on your price, you know, if it's a low impact, you know, a minor impact soft tissue case, a missed case, then it may not necessarily be worth us scheduling your deposition. You know, I need to know that in advance, and that's what's going to happen in that pre-call for me to say, all right, well, based on the length, you know, if I need to set aside 2 hours and you're telling me that your rate is, you know, $200 an hour, then that's something that I need to factor in and make a decision, a strategic decision of if I want to eat that cost for my client. So I think that's how you cover costs. A subpoena, now, if it is to trial or deposition, then yeah, you have to appear. That's what, you know, it's court ordered. You know, the clerk has signed off on it, and that's something where you need to make yourself available, or you could possibly find yourself in contempt, and that's, you know, obviously not a place where you want to be. Excuse me. Did I answer all of that? I know you had several parts to your question. I didn't.
Yeah, I think you did. The only I guess just slight, I guess, extra question would be, you know, being subpoenaed to court to testify in that respect versus being maybe called as an expert witness. Are those handled differently, or are they handled the same, or which one's better? I know if you're subpoenaed, you know, that's something where, okay, you can be in contempt if you don't show up, so you basically have to go. And if you don't go, then you're in trouble. But
yeah,
isn't there another way to have the person come to court?
Yeah, I mean, those are the ways, as you just mentioned. But the reason subpoena, if it's for trial, I'm going to subpoena you because that's a CYA for me. Because God forbid anything happens, I can now say to the court, hey, we subpoenaed this witness. We need to take a break, or, you know, maybe have this continued because my witness is under subpoena, and we need to work around it. You're not going to get thrown in, you know, you're not going to be fined or sanctioned. Usually most judges aren't for your first. So, but a subpoena is the way of making sure legally you are required to show up. So if any of you guys do get a subpoena, don't be offended. Don't take it personally. It's just something as a CYA to make sure that we're, you know, crossing our T's and dotting our I's with the court. But those are the way generally that you're expected to come to court if you are designated as an expert witness, and you're put on the witness list, which should be accompanied by a subpoena at that point.
Thank you.
Cool. No problem. Dr. Karhi?
Yes. So you talked about having additional documentation available, such as cheat sheets reviewing the file. What about clinical reasoning in your treatment protocol? Can you have those documents available with you, because they're bound to come up, and then you can just refer to them and tell them what your treatment protocol is, how it's based on 3 phases of healing, so on and so forth?
Yeah, I think that's a good idea. I mean, and it may be that we want to market, we want to tender it into evidence. So I think that is a you know, that's not a bad idea. Of course, you know, there may be some other evidentiary issues that may need to be tackled before, you know, that you may talk about. So I would absolutely say, you know, during that prep with your attorney, hey, look, I've got some treatises, I've got some you know, some research or some data that I want to bring that may, you know, bolster or support, you know, some of my answers. Is that okay? And at that point, I may be able to work that into the conversation. I may be able to say, well, you know, Dr. Carr, you testified earlier that, you know, based on this symptom, you did, you know, X. Can you tell us why you did that? And then that's what you could say, well, based on my research, you know, I've discovered that doing X is the proper way to make sure that, you know, that issue is addressed. And then I can follow up with, well, what research is that? You know, do you have that present? Yeah, it's in, you know, it's in Gray's Anatomy, and I have a copy right here. Boom, there it is.
Nice. Got it.
That makes sense?
Yes, it does.
All right, good deal. Anybody else have anything? I mean, I know that this is so wonderfully exciting and cutting edge information, but you know, anything else that I could assist with to make sure that everybody feels more and more comfortable? If you ever get the quote unquote dreaded notice of deposition. Look, I'll just say this, you know, your attorneys are going to be your best friends in this situation. You know, they are going to protect you. A good attorney is going to protect you, and they're not going to let you get thrown in there and just get sliced to shreds. They're going to kind of let you know what you need to focus on, and maybe even the temperament of the defense attorney, if it's someone that we've come across before. You know, it's something that you get better with the more you do it. So I would say that every opportunity you get to do it, you know, do it. Get deposed, because I actually say it'll make you a better physician in the fact that when you now learn how they're attempting to attack your work, then you can go back then when you're actually doing the work, and you can kind of close the gaps and address that with your actual treatment or even in your records. That's the only way, you know, that's how we got better as a firm. Is I have a directive that every attorney in my firm, every case manager, paralegal, you must speak to the adjuster and ask them why their offer is their offer. Because a lot of them will tell you exactly, well, I see that, you know, you guys sent out for an MRI a week after, you know, treatment, and we don't accept it until 2 weeks after. Then I can go back and tell my chiro, hey, only refer out 2 weeks later with his insurance company, because that's their protocol. So those are the little tidbits where you're not really going to learn the you know, the little cheats, the little cheat codes, if you're not going through depositions, if you're not having these, you know, candid conversations with your lawyer. Never position yourself to where, you know, you're so smart that you don't want to talk to the lawyer. Because there are things that you just don't know. There's no way you can know. You could be practicing 20 years, and yeah, you may be an expert on the science part, but then there's another part with personal injury that you just may not know. Or there may be parts in reverse. If I'm an attorney, I need to be educated. That's why I said before, talk to me, educate me. Tell me why you did something, so that I'll better know how to couch that question, or how to prep you to answer that before you say something that you don't mean, or you offer some testimony that's damning. So that's my main takeaway that I want you guys to take away from this: communication, communication, communication. I've had, you know, a couple chiropractors that I will never ever work with again, because it came time for deposition and they disappeared. Oh, I'm busy. I'm out the country. I don't know. You know, whatever they could say, just settle it. We'll take whatever you have. That's crazy. You know, it's like, man, you're that afraid of a deposition that you're just telling me, just take whatever, settle what we have. No, because that's not fair to my client. And it's not fair to us because we want to get paid. Obviously, we're not taking what we just have because we don't think it's a valuable offer on the table, and I think that's incredibly selfish. And I know that no one in here would ever do that, but I have had that happen before. And I will never, ever work with that group again. Dr. Garcia?
Yeah, I just wanted to chime in with what you said, having gone through depositions numerous times, both, in person and then through Zoom over the pandemic, and then also, going to court. Each time I do that, I come back and I learn something where I got to tighten up my notes. And, working with multiple clinics and having 4 clinics, having protocols in place, like Dr. Carr had mentioned, and things for treatment. And then just, taking what I learned from each deposition and line of questioning, like what kind of questions they're going to ask you about your degree, your education, your treatment, your billing. I mean, there's just so many questions that they'll ask you, and it makes you think like, oh, okay, I have to make sure I have the right or good answers for those things the
Absolutely.
next time, or we have to tweak things. And so it's a development that you come to appreciate, and you don't shy away from it. So I'm available for deposition, court appearances, expert witnesses, whatever you need, I'm there. So let me know.
Good deal. Good deal.
And thank you for doing this. Appreciate it.
Absolutely. So, one thing, it's not that, when we look at some of these physicians who are designated defense experts, it's not because they're not getting hired because they're amazing physicians, because they've testified so many times where they're not getting tripped up. They are literally expert witnesses. They have gotten their depositions down to a science as to how to answer, what to say, what not to say. So that's why I say to you guys, don't shy away from it. Of course, we're a trial firm, but yeah, we want cases to settle. That doesn't mean we want to take everything to trial. We want to make our money, the most money the fastest way possible. But you also can't shy away from trial if that's what the case requires. Embrace that moment, because it's going to give you the opportunity for live practice, and it'll make you a much better physician. All right, that's about it that I have. Unless y'all have anything else, let me know. Let me give y'all my cell as well. It's I shared it on the thing. I don't know, but feel free to text me if y'all have any issues, anything you need. I'm putting it in the chat. Oh, I see Dr. Walker's here. Dr. Leslie Walker, how are you? Is she still on?
Where is she?
Oh, I thought she signed it. She sent a message saying that she'd been. All right, but here's my cell. I'm trying to put it in the chat to everyone. Oh, she has no audio, but I see you here. Glad you could join us, Doc. Good to see you, kind of, even though your screen's black. 404-550-1148. Let me put it in the chat if I can figure that out. Oh, boom, here we go, everyone. Here we go. There we go. Text me so I have your information. Lock me in. Even if it's not my case, if you just want to say, hey, look, this is what's going on. What are your thoughts? I'll be more than happy. Let me be a resource. And, hopefully if we haven't worked together, we can work together in the future. And if we have worked together, then hopefully we can keep working together. All right.
Thank you so much. This has been a really great presentation. I think we'll get lots of hits on YouTube as well.
Good deal. Well, it's my pleasure. And hopefully you guys will take something from it, tell your colleagues, and I'd love to do it again. If it's anything else, I love pre-lit more than lit. I mean, obviously we all got to know litigation, but I think we all, as I said earlier, want this thing to settle in pre-lit. So I'll be more than happy to, I've done a few of the CE courses on pre-litigation, how to work up a case and so forth. I'll be more than happy to, do that again and keep adding value to our cases.
Thank you very much for being here. We really appreciate it.
All right. Absolutely. All right, guys. Well, I hope that y'all enjoy the rest of your day.
Thanks, you too.
All right. Okay. All right. Bye, everyone.
Go.